First case today is In Re EM. As you probably know, while we allot 20 minutes to a side, we typically go beyond that. So as long as we're asking questions, please continue to respond. And you need not ask permission to do so. May mean that at the end of the day, one party has more time than the other. It's just a function of how many questions we happen to have had. Okay, we're ready for council's appearances.
Monica Mayo on behalf of Youth Appellant EM.
John Nielsen for the state.
Welcome to you both. Let's begin.
Good morning. This case is about a child who was just 15 years old when the alleged offenses occurred, and a child who, while experiencing some of the worst conditions imaginable while growing up in war-torn Sudan, tried his best to fit in and adapt to a shockingly new society once he and his sister sought safe harbor in Utah. And this child, once given resources and positive support in the juvenile system, has made remarkable strides in his learning ability, social skills, and respect for others. He is on gold level status. He is a leader and a mentor. He will graduate high school in the spring, and he only continues to grow and improve while in the juvenile system. He's a child who should never face the prospect of the inside of an adult prison cell and be subject to incarceration with hardened adult criminals and gang members. And the only reason he faces that prospect today is because the juvenile court made numerous legal errors in interpreting and applying the retention factors, which directly led to the erroneous transfer. This court should therefore vacate the transfer order and remand for a legally correct analysis. I'd like to start with one of the more serious errors that I think the court made, and that was in its interpretation of the likelihood of rehabilitation using juvenile services and facilities. The court made three main errors. First, it conflated other factors with the rehabilitation factor. It also went beyond the scope of the plain language by considering the possibility of parole. And it went beyond the scope of the plain language in considering EM's options for continued mandatory services in the adult system.
Before you get into the specifics, can you explain why you see these as distinct factors that have to be treated separately? It seems like there's a lot of interplay between them and that they're interconnected. What is it about the structure of the statute or the plain language that makes you view these as distinct and separate factors that cannot be considered as a whole together?
Well, the statute is drafted and requires specific findings on each of the five factors. I think the statute looks somewhat simple at first blush. You have five factors you analyze, and then you make this contrariness determination. But what happens when you start to conflate factors is the analysis becomes very muddied and very confused, and it's easy to add weight to certain factors that does not belong there. And the weight of the factors becomes very important. And so when you start conflating factors, you increase the risk of the court making an error in applying the factors. And I think the structure of the statute requires discrete findings on each of the five factors before it moves to the contrariness analysis.
And I agree with you there. It does seem like the court has to consider and make findings on all five factors. But this seems to be a case where they're so interrelated. I mean, his rehabilitation needs are based in part on the severe trauma that he suffered, his need for rehabilitation. If he's not rehabilitated, that poses a danger to the public, and that could influence how long he needs rehabilitation before he's no longer a threat to the public. I mean, they just seem so interconnected. Wouldn't it be like a sort of an artificial exercise to ask the court to not consider the overlap?
Well, I think the court can pull facts from different factors. It just has to be careful to not add weight using the factors. So for instance, in the seriousness factor, using the aggravated and premeditated factor to say this is even more serious because it's aggravated, added additional weight to the seriousness factor, and the statute as it's written requires those to be separated out. I mean, it may be sort of an artificial exercise. That's for this court to decide. We have courts applying it just that way, and then we have a court like this who kind of intermingles. So there is some confusion about how juvenile courts should apply the factors and whether they should make discrete, concrete findings on each of the 5 factors before it moves on to the contrariness. So part of the reason we're here is we need some clarity about that. The problem has become there's so few of these cases now. There's just such a few number of children that are transferred at this age group that we don't have guidance, and we have really wide disparity in how courts are doing this.
Related to that, it sounds like from your briefing that you envision a court taking a look at those 5 factors and saying, I weigh this one this way, I weigh this other one this way, essentially putting them in buckets and assigning weight to them. Is there something in the statute that suggests that's the right way to do it, or would it be proper for the court just to do a more holistic review, make sure they're considering each of those 5 factors, and then deciding how together they all balance out, as opposed to really saying this one, it weighs in favor of, retention, but only to this extent. And this one weighs in favor of transfer and to this large extent. And then somehow doing like an equation to figure out the answer. Do you see what I'm saying?
Right.
So which do you think
Again, we've seen both approaches.
Okay.
One that I think led to a more concrete and correct analysis, and one that led to a very muddied analysis. I think no matter what, the weight that the statute appears to give the court a lot of discretion, but it giveth and it taketh away. Because it gives the court all this discretion to weigh the factors, but the ultimate analysis comes down to whether on balance it is contrary to the best interests of the child and the best interests of the public. That's a very difficult determination to make. I think however the court decides if it should be a more holistic analysis or more and a more individualized consideration, the court, I think that the holistic approach may give the court more permission to say, this crime is just so serious, I'm going to transfer. And that can't be how the statute is read. Courts are constrained. That is a direct file statute, and we have that for 16 and 17-year-olds, where if you commit murder or aggravated murder, there's no individualized consideration, there are no factors, you're automatically transferred to the adult system. So this statute, legislatures made a policy choice to keep that separate. And so I think the holistic...
I agree with you. Oh, sorry. Can I just ask one question about what you just said? You said that if the court just finds that it's just a really serious offense and is going to transfer, that's not permissible. But, the statute says expressly that the court can decide what weight to give the factors. And I realize we don't want a court just transferring every murder case, right? Because that would be equivalent of direct file. But why couldn't a court say this particular crime under these circumstances is so serious that factor really outweighs everything else and needs to be transferred? Is there something in the statute that would prevent the court from doing that?
Well, I think, yes. The court has to consider, even after it consider it very, very serious. But again, we have that mechanism. The legislature has chosen to make this statute different. And so it must, it must go through the analysis of each of the factors. It can give whatever weight, but then it still has to, at the end of the day, do an analysis on the contrariness of the juvenile system for the youth and for the public. I don't know if that answered your question.
Yes,
but-
and I'm sorry, I shouldn't have interrupted you, but when I heard that statement, I just wanted to explore it a little bit, so
Yeah,
thank
yeah.
you.
No, I think otherwise we just have another direct file statute and it renders all the other factors superfluous. And the legislature meant for this to be a very, for lack of a better word, a holistic look at the child and a holistic look at how rehabilitating that child affects public safety.
But would you agree that if the court did look at all 5 factors as it was required to do, but at the end of the day said the circumstances of this crime are so serious that I give the most weight to that factor, I give little weight to the other factors because they don't weigh heavily in favor of retention, and so I'm going to transfer?
I think you would have to have a significant lack of evidence on the other 3 factors to make that determination. You'd have to have a child, I'm speculating here, but with a huge criminal history, numerous services throughout the years, and has not been amenable to any kind of rehabilitation. I think you have to make that determination, and I think it would be a very rare case where you can find that the interest of the youth is outweighed by the seriousness of the offense.
Do you view this as a closed list? I mean, if a court was to consider a factor outside this list in making the determination, do you think that would run afoul of the statute?
I think, yes, I think the plain language of the statute, it's designed to sort of constrain the discretion that the court is given yes.
Okay.
So the statute reads, the prosecuting attorney shall have the burden of establishing, then lists the 5 factors, but it contemplates that even if the prosecuting attorney does not meet its burden as to each factor, transfer is still possible. For instance, here, the prosecuting attorney failed to carry its burden on the criminal record or history of the minor because there was none, right?
Right.
So the prosecutor may or may not meet its burden as to each particular element, but nevertheless, if you view it holistically as you described, ultimately it seems to come down to a very discretionary decision.
Well, I disagree a little bit with that. I think that the state has to put on evidence by a preponderance to show that it is contrary to both interests. And so if the state does not put on that evidence, I mean, and this case is a good example of that. The state put on no evidence. The defense did. It's not our burden, but in order to serve our client, we did that. But the state put on no evidence that that the juvenile system was contrary to the minor's interests.
Can you talk a little bit about harmfulness of an error in this context, where the ultimate inquiry, as you've detailed, is contrary to the best interests of the juvenile and the public, and the statute specifically giving the juvenile court the ability to weigh the factors and to assign weight? Let's say that a court considers something under 2 or under 1 that should have been properly considered under 2. How do we know that created a material impact on the decision? Like, how do we suss out whether it would have made a difference?
Well, let me look here. Because the court isn't just deciding whether the crime was serious or whether the crime was aggressive. It is assigning weight to those factors. And so necessarily when you add more weight to one factor, it takes away weight from, it's the bucket example, right? That the more stones you put in the seriousness bucket, the more it weighs in favor of transfer.
And I guess that makes sense to me if as I think Justice Pullman said, if we're trying to make this be like math, right?
Mm-hmm.
And it matters how those are weighted. But if it's something the court could properly consider in a different bucket, it seems like you still have the same number of stones going in. You just might have had one in a bucket maybe it shouldn't have been in. And I'm not saying that that's right and that's an error that should be corrected, but how can we tell if that had a material impact on the court's ultimate discretionary decision?
Well, I think in this case, you have a child who, yes, the crime was serious. They're always going to be serious. So seriousness, I mean, the defense almost has to concede that in every case. We're not going to make a lot of arguments about the seriousness. The legislature has written the statute in a way that it defines the four arguably most serious offenses that there are. I lost my train of thought, I'm sorry. Can you repeat that again? I know that was a lengthy question.
Yeah, no, and it was a poor question. So I'm just trying to understand how when we have a statutory scheme that invests the juvenile court with so much discretion, how do we know when an error in putting something in the wrong bucket really impacted the decision such that the court should have reached a different, or could have reached a different decision, abused its discretion in the ultimate determination?
Well, that's where I was going with this, that you have a case like this where you have a youth who arguably committed a very serious crime, allegedly at this point, but was highly amenable to treatment and had no criminal history, had never even been given a chance to be rehabilitated by the system. And it resulted, that can't be contrary to his interest to keep a child like that in juvenile court.
And that's my question. So is there anything in what you described that you believe the juvenile court did not consider in reaching its decision? Because it seems like the juvenile court took all those things into account, but decided it differently than maybe somebody else would if they had been making the decision.
Right. Well, I think the court gave too much weight to seriousness because it considered all 16 offenses instead of just the qualifying offense. The plain language is very, very clear on that point, that it's only the qualifying offense. And it considered 16 other alleged offenses. There will be accountability for those. Those have already followed him to the district court.
Can I just stop you there and ask you?
Yeah.
So is there the way you read the statute, is there any place in the statute where it would have been proper for the juvenile court to consider those 16 offenses? Is this a case of the juvenile court considering something that it had no business considering, or is it that it considered it under the wrong factor, in your view?
In my view, it had, according to the plain language of factor number is, 3A. The plain language of that statute limits the court to looking at the seriousness of the qualifying offense. That is the 2 bullets that killed S.A.
Gotcha. So I got that argument, and I'm with you there.
Okay.
But is the other 16, right, is there no factor under which you believe it would have been proper? So, for example, the criminal record or history of the minor, is that properly considered criminal history?
No.
Does it go to the likelihood of the minor's rehabilitation?
No.
Does it go to the minor's mental, physical education, trauma, or social history? So there's just no place for the juvenile court to consider that?
No. They've made that statute decidedly narrow.
Sorry. Can I have one last one?
Please.
So what about B, the extent to which the minor's actually, well, I'm sorry, you'd say that just in the qualifying offense.
Yes.
And so you can't look at other conduct to decide whether it was committed in an aggressive, violent, premeditated.
You can look at the
manner.
aggressiveness with respect to the 2 shots, but it's confined to that.
Okay, I get your argument.
Legislature, and that's why I know the statute really, and maybe there is some ambiguity here as we're speaking, and you can look to legislative history. This statute is designed to be very, very narrow for a reason. It's evidence-based. There have been all sorts of reforms in Utah around youth, and the process over the last few years as we've watched these statutes evolve, it is narrowing and narrowing and narrowing, because it should be the very, very rare case that a 15 or a 14-year-old is transferred to the adult system. It just results in very poor outcomes for both, especially for the community, but certainly for the child.
What if the other offenses, the non-qualifying offenses, hadn't been charged? Let's say they hadn't been charged. Could the court have considered the fact that he is alleged to have committed murder by firing multiple rounds into a sizable group of people?
Not under the plain language of the statute.
So the court can never consider the surrounding circumstances?
Not the way the plain language of the statute reads. It's very, very narrow.
So I think I know your answer, but let me ask one more. What if the surrounding circumstances were not offenses in and of themselves? Like, it wasn't just that he wasn't charged, they just weren't crimes. Then could the court only consider the fact that he fired the 2 bullets that killed the victim?
Yes, I think that they're constrained to consider the seriousness and the aggressive, premeditated, willful aspect as to only that qualifying offense.
So they could consider...
Because in sub 10, it talks about the separate offenses, right? And they can all be included as a single criminal episode being transferred. But the only thing the court can consider are the surrounding circumstances of the qualifying offense. And I know that her reading of the statute may seem reasonable to some people. I'm not disputing that at all. But if we're looking at statutory interpretation principles and the narrowing of the statute by the legislature, the intentional choice to pick those 4 qualifying offenses, we're limited to looking just at the qualifying offenses.
So with respect to those 2 shots, though, could the court still consider the fact that they were fired into a group of people and could have hit other people? Could it consider that it was allegedly racially motivated? I mean, what circumstances can the court consider other than the fact that he pulled a trigger twice and they...
I think the court can look to his choice to pick up, well, if that's what indeed happened, my client says that is not what happened, and I have good reason to believe him about that. But no, I think it's constrained to consideration of that. It's narrow by choice. And I know I keep giving you the same answer, and I know that's not very satisfying.
Okay.
But again, I think it's Terry v. United States. We cited it in the reply brief. And that case says we may not like the result, but the text requires it.
Yes, I was just trying to figure out where the line was on your argument. At
I
what
think it's
point?
very, very narrow.
Okay, thank
It's
you.
designed to transfer as few children as possible.
Speaking of the narrowness of the statute, if I could turn your attention to factor E, the state bears the burden of showing that the likelihood of the minor's rehabilitation by the use of services and facilities that are available to the juvenile court. And I know you take issue in your briefing with the fact that any comparison to the services that would have been available in prison is inappropriate. The focus should have been exclusively on the juvenile court. Now that, of course, turns on this list being an exclusive list, and you've addressed that in response to other questions. But if we view this holistically, well, first of all, I'm going to ask you again to point to language that highlights the fact or demonstrates that this is intended to be an exhaustive list rather than just the minimum things that the prosecuting attorney bears the burden of establishing. If the ultimate objective is to do what's in the minor's best interest and the public's best interest, what's wrong with comparing the juvenile system and its capacity to rehabilitate the minor with the prison system?
Well, that's the problem with the way you framed the burden. It's not whether it's in the minor's best interest and the public's best interest to transfer. Then you're starting at a neutral place and you're analyzing what can the juvenile system offer, what can the adult system offer. This is a contrariness analysis, which means you start with the presumption that they stay. And sending them has to be contrary to the public's has to be contrary to their interest. It's not best interest to transfer, and that makes a difference. It's not just semantics. And the reason this is problematic is because in doing some research for oral argument, I actually reached out to a clinical support services director at the prison to find out what kind of services that we're looking at. I contend it's totally irrelevant to the analysis. The language of the statute is very narrow. It says whether this child can be rehabilitated with juvenile services and in a juvenile facility. It mentions, the statute says shall make findings. And if we start allowing them to consider anything, why even have these findings at all? The legislature has said you consider these things. We can't consider, and the problem with considering the services offered in the adult system is that there are no services. So he goes to juvenile court, say he's retained, he's transferred, which he has been. He spends 9 years of his life in a rehabilitative setting, a secure campus-like setting with a ratio of 1 to 15, or there's supposed to be 15 kids in the facility. Ratio of staff is like 5 to 1. Gets all these risk-reducing rehabilitative services, age-appropriate. He comes out and he's basically been rehabilitated to the best. We're not talking about cure. We're talking about making him safe enough to return to the community. And then we transfer him to the adult system, and they have 140 therapists to 1 inmate. It's based on acuity and need. He most likely would not receive any services until about 1 year to 2 years before he's released. So you have this child that we've done all this work on this child.
This is a factual argument, right? Was it
Well,
made below it? Maybe I could phrase it as a hypothetical for purposes of my question.
Sure.
Hypothetically, if the ultimate objective, and how would you describe the ultimate objective?
Of the statute?
Yeah, is it not to do what's in the best interest of the child and the public?
No, it's,
Okay.
you have to determine what's contrary to their interest. Is it contrary to their interest to remove them from the rehabilitative nature of the juvenile system with what we know about children? And all the research is telling us it is rarely going to be contrary to their interest. It's not whether it's in our best interest to send them. That's a totally different analysis.
So in assessing whether it's contrary to their interest to be transferred,
I think the question, oh, sorry.
well, go ahead.
I think the question becomes, if you're looking at contrariness, you have to make a determination that the juvenile system is wholly unfit and inadequate to transfer him. I think that's really what it boils down to, is you have to make a determination that the system we've designed to treat and rehabilitate children is ill-equipped and poorly designed and cannot do it. And the only evidence we have on the record here, and I see where you're going with a factual question here, but the only evidence we have on the record here is that he's highly amenable to treatment, which has been borne out by the 2 years he's spent without even any services. He's just been temporarily housed in detention. But all the court speculations about him, his learning disability, he'll have a hard time assimilating information that has turned out to not be true. It turns out the expert, the child psychologist who does this work, was correct. It was a language barrier issue. Once they resolved that, he has excelled. He's graduating, he's reading on grade level. So it's a heavy burden for the state to prove that the juvenile system is not contrary.
So let's assume the state does prove that his rehabilitation prospects are better in the prison system. They're just better. I know you think that shouldn't be considered, but would it not then be contrary to his interest to be placed in a system with less of a prospect of successful rehabilitation?
There would have to be the state would have to put on evidence that he will receive services and that they're better than the ones the juvenile court. There has to be evidence. We can't just say, we think sending him to the adult system is the better way here. We can't do that. This analysis, it's this double negative that's very confusing and semantically gets confused sometimes, but it has meaning. It's done that way for a reason. So there would have to be evidence in the record that says going to prison and waiting till 1 to 2 years before you're released to get services. Meanwhile, being in a heavily gang-entrenched, crime-ridden, cross-contaminated environment with more sophisticated criminals, that's the better system. And still, that confuses the burden, but there'd have to be evidence in the record that that was the better solution, and there's no evidence of that. Instead, there's overwhelming evidence that the juvenile system is the correct.
Can I just ask you, in your view, what is the legislature distinguishing in subsection D when it refers to both criminal record and criminal history? What are they doing there?
I think some drafting errors, because it's not really, a child's not going to have a criminal history at all. It would be a delinquency history, so I know that's incorrect, and semantics matter in juvenile court. I'm not sure exactly what they mean by that distinction. And I know this is not going to be a satisfying answer, but in this case, I want to be really clear that the state, the court below and then the state again on appeal relies heavily on the fact that he picked up 2 charges as soon as he came into into detention. First of all, that's not unusual. And second, neither one was dismissed and one was never even petitioned. So it wasn't even deemed to be true. I do agree that adds some ambiguity about criminal record. But again, record to me suggests something in your past that's already been adjudicated.
Yeah, but what about history? So criminal record, and I take your point, right? Maybe
Right.
it should read delinquency record, not criminal record. But what's the legislature getting at by drawing a distinction between record and history?
I'm not sure. I'm not sure about that.
Thank you.
Looks like those are the questions.
Those are the
Thank
questions?
you.
Okay.
You'll have your full rebuttal time.
Forward. Okay, thank you.
Mr. Nielsen?
May it please the court. Chief Justice Durant, you asked about whether this is comparative. And I would point the court to Record 400, where this is defense counsel below saying what the essential inquiry is. Both logically and analytically, the essential question is which of the 2 systems will best serve to both rehabilitate him in his transition to adulthood and also promote the long-term safety of the community. I think it is just some semantics to say, no, it has to be contrary to this, to that. Well, in order to say what's contrary to best interests, you have to know what best interests are. And then you know what supports it and you know what is contrary to it. So it is essentially that inquiry. A lot of the court's questions also went to how holistic is this. I think subsection 4 makes this entirely holistic because the juvenile court has entire full discretion to decide how to weight all of these factors. That, to me, along with the general tenor of juvenile court proceedings, which is investing a lot of discretion within these specialized judges who have a lot of experience, a lot of training in dealing with children, and so I think that's the textual hook for all of this, for this holistic inquiry.
Can I ask you about that? So is there anything, where the legislature has phrased this in terms of the amount of weight of each factor, I mean, does that require the juvenile court to make sure that it is getting the right facts in the right factor? And that we need to make sure that the juvenile court is doing that correctly so then it knows how to assign those weights?
Well, the state sees it very differently than opposing counsel, as is often the case. Part of that stems from, and this goes to a lot of your questions, I believe, Justice Hagan, on what offense means. What does offense mean? Does it mean you just look up the code section and say, oh, there it is, it's serious? Or does it mean what happened here? Not all murders are created equal. If people rob a bank and then fleeing the scene, they run over somebody in a sidewalk, that was no part of the plan whatsoever, but is still technically murder, felony murder, right? That's very different than a drive-by shooting where 4 people are injured and 1 is killed in a racially motivated, gang-motivated shooting where they're allowed to kill people because of their race. That has to be considered. That has to be part of the offense. And again, even if you read it as narrowly as counsel would have you, offense here includes the theory of felony murder. What provides the mental state element of felony murder? The predicate offenses. What are the predicate offenses? All of these other shots.
But even if the state hadn't charged felony murder, would you still be arguing that the court can consider the surrounding circumstances of the
Absolutely.
qualifying offense?
Absolutely. I think, again, it would be just this rote exercise. I just found the case this morning, but it's a Court of Appeals case dealing with the seriousness of the offense. Well, I guess this was part of my 24J letter. NHB says seriousness has to mean more than just a hollow exercise in confirmation. That is just kind of looking up the code and saying, oh, yes, that offense is serious, or it's listed within the transferable offenses, therefore serious. That would always be met every single time. It would not serve the interests of juveniles to consider that just that narrowly, because it wouldn't allow for this holistic determination, which I think, again, the statute contemplates, of saying what's right for everybody here. What's right for the public, what's right for this juvenile, and what really happened. What happened in this offense, and going to the second factor, how much was this person responsible for all of the serious things that happened? And that's where some of the overlap comes in here, which defense counsel is faulting the trial court for, but it depends on the facts. A lot of the court's concern in the old days of the Serious Youth Offender Act was that they were treating, and you see this in the Van Huysen case, treating somebody who's kind of marginally involved the same as those who were involved in the core. Mr. Van Huysen, for example, provided a gun that was later used to rob some drug dealers and resulted in some violence. Is he as culpable as somebody who was there and was holding the gun and was shooting it? No. So in that case, those factors are going to be a little bit more separate. But depending on the facts of this case, the seriousness of the offenses and the aggressive, violent, premeditated nature of it overlap because he was the one holding the gun. That's what the trial court found, and that's not challenged at this point, nor could it be at this stage. So it's necessarily holistic. What the statute does say is that the court shall consider and make findings on. The juvenile court, in its 22-page, single-spaced ruling, certainly considered each one of these factors. And there was, to the extent that there was some factual overlap and some overlap that contributed to, having a racially motivated, premeditated murder makes it a more serious murder than other murders. That goes into both factors 1 and 2, but where the court can weigh, and this goes to your question, one of your questions, Justice Pierce, where the court has this discretion under subsection 4. The short answer, I think, is it's going to be really hard for a juvenile to show a harm from any sort of overlapping analysis because the court has this sort of thing. But the question is really, did the court consider everything it had to consider? And whether it's exhaustive or not, this list, it says it shall consider and make findings on this. It doesn't say it shall not consider anything else.
So your position is that it's not an exclusive list?
I don't think it is.
As long as the court considers all 5 of these factors, it can consider anything else it considers relevant?
To be relevant. Though, to be clear, I think it's going to be difficult to brainstorm something that doesn't fall under these pretty general umbrellas. It's a pretty holistic inquiry as it's framed, and you could likely fit just about anything in there, I think.
What happens if the state doesn't put on any evidence to one of these factors? So for example, the 5th factor, the likelihood of rehabilitation with the juvenile services. Let's imagine the state doesn't put on any evidence of that factor. What happens then?
Well, the juvenile court is still required to consider and make findings on that factor, and is not required to accept the evidence that the defendant puts forth.
So in this case, did the state put on any evidence that would demonstrate that the rehabilitative services in juvenile court would not adequately serve this juvenile?
There's more than one way to put on evidence than just calling witnesses. The state did also cross-examine the defense witnesses and established very clearly through that cross-examination that all of these services, with 99% of these services, with the exception of more frequent review in front of the youth parole authority and supervision by their less heavily laden caseworkers as opposed to AP&P agents, Setting that aside, every other service that is available to a juvenile in the juvenile system is available to EM until he ages out, just like anybody else.
But did the state show that at the end of that process, the end of the 9 years, that he would not be adequately rehabilitated? Is there some evidence the state put on to show that, and to show that the services he would receive in the prison system after that would serve his interests?
Yeah, so determining rehabilitation requires a base point of where he's at right now. Where he's at right now takes in, again, holistically, a lot of what's going on here. What happened here? What is the offense? What was his role in it? And his trauma history came into play here, which defense counsel takes issue with and says, well, you can't hold that against him. There's no inherent directionality in the statute, or it just says you shall consider it. When you have somebody who has the kind of trauma history that he has, it's not unreasonable to say, like the juvenile court did here, man, the odds that he's going to overcome this in the next 5 to 9 years are probably pretty slim.
And what was that based on?
Well, what was that
Where are
based
the
on?
odds? I mean, is there data? Is there something about his particular trauma that you would say, we've got evidence or histories that show that 9 years is not going to be enough here? It just seems to me like ultimately on that point, the juvenile court was just unsure. I don't know if he's going to be rehabilitated, so I'll send him to the prison system, and that way, if he's not, someone can keep him incarcerated. And given that it's the state's burden to show it's contrary to his interests, to be retained, I think, again, double negatives. I'm just curious what the state pointed to or what the court relied on other than just her uncertainty. If there was something that made her believe that it was unlikely that he would be rehabilitated by that time. Was there anything in the evidence to that?
Well, the court took issue with, so the defense put on evidence that it would be
Right.
better for him to stay there, and the court said, well, it's true that you said that, but you didn't take into account these other things.
What were those things?
His 2 more assaults while in custody, and the depth of his trauma. So one of the things that the psychologist said, as I recall, was that he's not psychopathic. He has post-traumatic stress disorder, and he has this nonverbal learning disability that makes it difficult for him to connect cause and effect. And given the extent and depth of his trauma that happened in his youth, I think the court could take that, the court reasonably did take that and say, that's a tough row to hoe. It's going to take him reasonably a very long time to come back from that. And what happened here was so serious and affected so many people for such to him through the adult system after he aged out of the juvenile system.
Did the defense present evidence as to potential downsides to moving him to the adult system?
The only thing that they focused on was, well, he's not going to have as frequent of reviews with the Youth Parole Authority, and he's going to have a more heavily laden case officer. Those are the only real differences that I could discern between whether he is transferred or not. Other than the ultimate, he would be released into the adult system if not paroled sooner kind of end game there.
I thought that the best argument that the defense made here was that, if this can all be considered in this manner, and we're only talking about 14 and 15-year-olds who committed the very serious offense of murder, why wouldn't the court always go this route? I mean, if the child is still going to be in the juvenile detention center with its resources until they're 25, why wouldn't the court always say, look, just in case they're not rehabilitated and are still a danger to the community, I want to transfer this to district court so that they'll have to be evaluated at that point by the parole board. That seems like a pretty good argument, because I could certainly see a juvenile court judge, when you have a serious crime as murder, saying, why take the risk?
Because not all murders are created equal, and not all juveniles are the same. Again, go back to my example of the fleeing from the bank robbery and hitting somebody in the crosswalk. That is a murder, that is very serious, but it is not the same thing as a racially motivated, premeditated, grab the biggest gun you can and you unload it on a group of a targeted race.
So
and
you
take out a
think
bunch
that-
of people on purpose.
You think in that circumstance, the juvenile court might say, I'm confident that this, at least confident enough, that this juvenile will be rehabilitated and safe to release into the public by the time they're 25, so there's no need to transfer it.
Well, and to be clear, Judge Eisenman here could have made the other call.
Sure.
Could have gone the other way, right? But we trust this call to be made by juvenile court judges because they are specially trained and they are there, right? This is an institutional competence question. This isn't just some abstract paper inquiry. This is looking at the child, talking to people who work with the child and trying to figure out what is best for everybody. And I object and take issue with when Ms. Mayo goes on and on about what has happened since then. That is irrelevant to the district, through the juvenile court's decision. It was not before the district court, and it is outside of the record. And this court should not consider any of those statements that she has made when making its decision on the juvenile court's decision with the evidence before it. Just lastly, Justice Pierce, you asked about what does history v. record mean in sub D. I think they have to mean different things. I think criminal history or criminal record means what's on paper. You know, what does the rap sheet say? What is your conviction rate or your list of priors? What is that? That's different than history. You can have a history without having a record. Many people do because not everybody gets caught when they do things. So I think there is a distinction there that further lends weight to the juvenile court's decision. It didn't decide it on that basis, but it could have said, for example, his 2 assaults while in custody pending this. I think that's part of his history, even if it's not part of his record.
And those did occur before this hearing?
Yep. If there are no further questions.
Counselor, just quickly, what you said about his going to the juvenile section of the prison?
No, I believe he's held in the custody of Juvenile Justice Services until he could age out at age 21, or the district court could, or the juvenile court or district court could make a finding to retain him until maximum the age of 25. But I believe he will be housed within the juvenile system and not in the adult system.
Is there anything in the record to that end?
That was discussed at the hearing. That was my memory. That they said, yes, he will, this is where he will be regardless, and all these services will be made available to him. And even if that's an inference, it's a very reasonable inference, because if somebody's at the prison, they're going to be far away from all the juvenile services physically.
Thank you.
If there are no further questions, I urge this court to affirm.
Thank you, Mr. Nielsen. Ms. Mayo.
Try to address. I guess what I will say first of all is why even have the statute if the state's approach is correct? If the judge can take a look at anything he or she wants and just determine what's right, why did the legislature create this scheme? There has to be, the legislature meant something when it created this statute, and it said you shall consider these factors. It didn't say you can consider whatever you want. And what the court did, there wasn't any evidence. State put forth no evidence, not a preponderance, but zero evidence that he could not be rehabilitated. And the only thing that there was testimony, that is in the record, that he was doing very well in detention and had become a mentor and all of those things. His subsequent education, I just point out, because it shows that the juvenile court's predictions are just that. She predicted things. She went, juvenile courts, we give them wide discretion, but they can't make legal errors. And she went beyond the plain language of the statute several times. And the court can't do that. It has a lot of discretion, but I feel like I'm usually arguing the exact opposite. So when the state argues that we should go outside the bounds of the plain language of the statute, yeah. So anyway, the statute is drafted the way it is. It means something, and we should follow the statute. Otherwise, why do we even have it?
I think the state's argument was it would be hard to go beyond these factors. They seem to be all-encompassing.
Yeah, I mean,
think maybe the
But this
most,
idea that the court should just consider whatever it wants and determine what's right is not what the statute says.
one of the
And
things that I kind of struggle with is, as Justice Pullman put it, you seem to be taking more of a mathematical approach and also kind of a compartmentalized approach where nothing related to one factor can affect another factor. Does the statute contemplate that level of precision? Or at the end of the day, is it taking all these things at a minimum, taking these things into account?
I mean, according to the case law, we're supposed to read a statute as narrowly as possible if it fits with the purpose of the statute. The purpose of the statute is to limit children of this age, very young children, going to the adult system. The statute, I believe the text matters and that it should be interpreted according to the text of the statute, and it is a narrow
So
statute.
where in the text does it suggest that these must be wholly independent and compartmentalized findings? And there can be no reference to facts related to other factors. Where does it say that in the statute?
Well, it doesn't say that. And I think, again, that's why we have ambiguity in how courts are applying this, and we need direction from this court as to whether it has to be that concrete. And if you start letting juvenile courts go outside the bounds of the statute, as you have things like happened here, the juvenile court should not be considering the possibility of parole, and here's why. In following up and preparing for argument, I knew this question would come up. And so what will likely happen, and this is all very much a moving target, but likely 6 months before the transfer happens, there will be an administrative review, not a substantive review. And his first parole date will be set at that point. If he's convicted in the adult system and he gets a 15 to life sentence, his parole date will be 15 years, so he'll be 30 years old before he gets an actual parole hearing. That's why it's improper to go outside the bounds of the statute, because we had improper things considered. I want to be really careful about, one thing I think is great about this statute is that, and it fits with the evidence, that it's a good thing that we're taking children and letting them be provisionally housed and receive services. That's a really good thing. But we can't throw our hands up and say, in close calls, I'm just going to rely on the fact that he's going to get, either way, and the court does that in the very first line of her contrariness finding on page 454. She kind of hangs her hat on, he's going to receive the same services whether he's in the juvenile or adult system. That doesn't matter in the analysis. First, if a child doesn't deserve to be transferred, they don't deserve to be transferred, and that's what the statute requires and justice requires that. And there is trauma in transferring a young person who's received 9 years, 10 years of service, and then throwing them into general population, in 30 to 45 days after they've been in this secure care environment. So there's trauma associated with that. The YPA services, that is a big deal. We're talking about reentry services, and what the juvenile court provides is they're taught to budget. They help them find a job and develop their resume. They help them with transportation. They take them shopping for groceries, finding a therapist, individual therapy and family therapy. They get their driver's license. They have a community supervisor, and the ratio does matter. 50-to-1 supervision versus 10-to-1 supervision is a big deal. And we know that reentry is a point where it's one of the reasons we have so much recidivism in the adult system, because we have terrible reentry policies. In the adult system, in the prison system, the staff ratio is 50-to-1. They point them in the direction of housing. They don't find them housing. There's no help with job applications. There's some pro-social activities and things they encourage, but this is really punitively based. There's consequences if you don't comply, sort of thing, whereas opposed to this holistic approach with what the YPA does. And just, I know I'm out of time, but I will just say that matters, because regardless of what this court does today and regardless of what the adult court or the juvenile court does later on this year, EM is eventually going to be released into the community. And we have to ask ourselves, do we want him released back into the community after receiving 5 to 9 years of intensive, evidence-based, age-appropriate, trauma-informed rehabilitative interventions with wraparound services from the YPA? to help him transition to the outside world? Or do we want him released back into society after he's spent 15 years or longer in an adult prison with few, if any, services, heavily entrenched perhaps in gang life as a means of survival, and with no transitional services back into the community? I suggest we want the former. EM has no prior criminal history. He is low risk to reoffend and highly amenable to treatment. That's what the med expert said in this case. That's the only evidence the court had. This court should conclude that the juvenile court erred in its application of the factors by going outside of the factors, which resulted in an incorrect weighing of the factors. And this resulted in an erroneous transfer to the adult system. The state put forth no evidence, let alone a preponderance of the evidence, that retaining EM would be contrary to the community's and to EM's best interests. This court should vacate the retention decision and remand for a correct legal analysis. Thank you.
Thank you, Ms. Mayo, Mr. Nielsen.
Thank you.
We do appreciate your arguments here today as well as your briefing. We're going to take a quick break. When we return, we'll hear the case of State v. Jennings. Court is